on the replying affidavit sworn by Charles Hinga. The same is sworn on the 23rd of March, 2026. My lords, my lady, we also rely on the submissions, the one that are dated 19th of March, 2026. Just a brief highlight, my lords, my lady. This being a constitutional petition, it is incumbent upon the petitioner who has filed this petition to lay a basis for his case, and the burden of proof lies with the petitioner. It is our humble submissions, my lords, my lady, that the petitioner has not been able to meet and satisfy the burden of proof to warrant the grant of the declarations and the prayers that are sought at the foot of the petition before you. My Lord, I rely on the Supreme Court decision in the case of Samson Guer and 5 others versus Kenya Medical Association Institute, Kenya Medical Research Institute, is a 2020 KESE. And my lords, I make reference to paragraphs 48 to paragraph 50 of that decision. Secondly, my lords, a lot of heavy weather has been made in respect of Article 10 and the question of public participation. My lord, looking at that particular provision, I invite the court, when it retires, to look at annexure. I relieve them with the court. Yeah. And my lord, this just shows how far we have gone in terms of public participation. Yes, my lord, I will leave them with the court. My lord, looking at CMH1 in the affidavit of Charles Hinga, CMH1, which is at page 14, start from page 14 of the affidavit of Charles Hinga. We have gone into great length to demonstrate that public participation was undertaken in respect of the project. A submission has been made that this was land for surrender, that these residents surrendered this land. There is no material before this court of any surrender made by any of these residents for the so-called road or railway buffer. It is incumbent upon these residents to demonstrate that if at all they were even there to surrender the land, or they even owned the land in the first place, for them to be able to effect any surrender. And my lord, I invite this court, even as it looks at the national values under Article 10, and I liked the submission by my colleague, Mr. Dudley, on legitimate expectation. And he proceeded to submit that government must keep its word. My lord, under Article 10, specifically Article 10(2)(a), one of the national values and principles of governance, other than the rule of law, includes democracy and participation of the people. And in that particular aspect, and it's so usually left out, democracy. The government has a duty, has made a promise to the people to provide housing, and it's on that basis that the government was given the mandate by the people through a democratic process. And we are keeping and ensuring that the rights under Article 43 are kept to the letter. And my lord, in respect of this public participation, I invite the court to look at the decision of the Supreme Court in Communication Commission of Kenya versus Royal Media Services. It's a 2014 decision. This is a justifiable right, which rather than a procedural nicety. And from the document that we have presented before the court, we have been able to demonstrate that the government went to great length to take the views of the people when this process was being conceptualized. This court is being invited to make findings on the procurement process that was taken for purposes of granting this particular tender to the 11th respondent, it's our submission that this court has no such jurisdiction to deal with the questions of procurement under the Public Procurement and Asset Disposal Act. As I finalize, my Lord, I do submit that the 2010 Constitution has been argued provides for participatory democracy, where the public power is exercised in trust for the people. And I urge this Honorable Court to make a finding that in purposes of effecting this project for the providing of housing for the Kenyan people, that particular public participation as envisaged by the Constitution was adhered to the letter. I hand over to my colleague, Mr. Nura.
The issue of public participation has been argued significantly by the petitioner and counsel for the interested party. My Lord, I humbly submit that it is not only the document that is CMH1 that provides for the public participation that has been conducted for this particular project. My Lord, a brief background of these affordable housing projects would take us back to the Finance Act 2023, Section 84, which provided for the housing levy. That was eventually quashed, and public participation was indeed conducted and was found in petition E181 that public participation was sufficient. After quashing for lack of a legal framework, the government established the Affordable Housing Act, which is the Affordable Housing Act, which these projects are based on. It is the implementation of the Affordable Housing Act that the Southlands project arises from. So therefore, my Lord, there are legislation, in the implementation of that legislation, significant public participation was conducted, and significant public participation has also been conducted in this particular project we humbly submit. And that one can be found in the documents. That is the public participation report and the public participation minutes that are CMH1 in the affidavit of Charles Hinga. My lords and my lady, I humbly submit that the only constitutional question or threat of violation of the Constitution lies under Article 43(1)(b). And the only party that intends to threaten to violate a constitutional provision, in this case, I humbly submit, is the petitioner himself and the interested parties. My Lord, this article imposes a positive and immediate obligation upon the state to ensure access to adequate and accessible housing. That led to the implementation of the Affordable Housing Act 2024. And my Lord, there is a question of interpretation or realization of these rights under Article 43. Now, this Honorable Court has been enjoined in how it should interpret or it should ensure the implementation of Article 43. Article 25 imposes a burden on this court. This Honorable Court is enjoined to facilitate rather than hinder the progressive realization of the rights under Article 43.
Mr. Nuru, because of the limited time and yes, to have a structured process,
yes, madam.
You can be very sure that what you are submitting on might not be the issue before us. What you are saying is true, and we all agree, including the petitioner. There are only two issues here. Whether before commencing that process, and you've addressed one, and Mr. Alan Kamau has also addressed all of them in general, whether there was public participation, two, whether there was an EIA report, and whether Regulation 17 in terms of application and assessment was done, and thirdly, the issue of that land. Which land are we talking about? don't go so much into Article 43.
Most obliged.
Yes, because you will end up not addressing.
My Lord, the
those
reason
three issues.
the reason I went into Article 43
We actually
is
know about all those
is just to insist on public interest, my Lord.
Yeah, we know.
So-
People have right to housing and all that. So let's just deal with this project. Was the law followed?
Yes, my Lord. So the allegations.
People need houses. That one is a fact and it's a right.
Yes, my Lord.
Mm.
So, my Lord, the allegations by the petitioner, one of which is public participation, I have already covered. The second one being the ESIA report and the license by NEMA having not been issued before the project was commenced. My Lord, in the affidavit of Charles Hinga, we have significantly and substantially covered those two issues. My Lord, we submit that we have provided a ESIA report. That one is CMH3 in the affidavit, CMH2, apologies, my Lord.
Which report is that?
The ESIA report.
That page?
That
You're
is
saying that's an Excel?
CMH2. And the license is CMH3. My Lord, CMH3. My Lord, our submission is that that license has not been challenged ever since it was issued. My Lord, the environmental impact assessment report finds, and the purpose of that report, my Lord, is to provide evidence-based evaluation of potential positive and negative environmental, social, environmental, cultural impacts on the project. My Lord, no adverse finding was made in that report as to any threats or dangers that that project poses to the environment. My Lord, it is my humble submission that the prayers and the submission of the interested party is a claim of inconvenience. And my Lord, inconvenience cannot be used to stop a project that is within public interest. My Lord, all projects cause, in one way or another, an inconvenience, whether noise, whether dust, and if those were grounds to stop any project, then there would be no development in Nairobi. My Lord, I think lastly I would have to fast forward my submissions to the issue of a structural interdict. Mr. Otiel Dudley had predicted that these submissions would be made by myself, and I would not like to let him down. My Lord, submissions have been made by the petitioner that this would not be an opportunity, or the court cannot, in this case, grant any structural interdict for the respondents. My Lord, he contradicts his own documents by making such a statement. My Lord, if you look at the prayers of the petition, that is prayer 8, prayer 9, prayer 12, and prayer 13 of the petition, the wording of those prayers are set on compliance, and this court to ensure compliance. And that is the very basic nature of a structural interdict, my Lord. My Lord, all failures or delays in submission of the report or issuance of the license were not occasioned by the first to the seventh respondent. My Lord, it was a failure of the system that has been captured in the affidavit of Charles Hinga, and it has been explained in detail. My Lord, all that we say is that what does the ESIA report and what does the license seek to cure? It is to ensure that there are no adverse risks to the environment and to the people living around it. So, my Lord, in the presence of that report, now presently on record, and with the issuance of a license, my Lord, it is our humble submission that the issues raised have been overtaken significantly by events. And that would be cured by our prayer for a structural interdict for this honorable court to deem that these documents have, or the licenses were duly and legally obtained. My Lord, there are no constitutional infringements, threat of constitutional infringements that have been demonstrated by the petitioner and the interested party that would face them or their clients. My Lord, we humbly submit that this petition is one for dismissal. Thank you, Madam.